Honorable guests, dear participants, dear organizers, thank you very much for the opportunity to address you on such fundamental issues for Europe and our societies. Member states may have different national identities, legal systems and traditions, but the core meaning of the rule of law is the same across the EU. These core principles of the rule of law are part of our common constitutional traditions, be it legality, legal certainty, effective independent and impartial courts, or effective judicial review, separation of powers and equality before the law. Accession to the EU was the free choice of every member state. It has not been imposed on any of them. And when joining the EU, all member states commit to upholding these common values. Democracy, rule of law, and fundamental rights are the foundations without which no other EU policy can thrive. It is thus necessary to discuss the rule of law situation among the EU member states. In 2019, the Commission created the rule of law cycle with its annual rule of law report as a preventive instrument. It assesses the rule of law situation in each member state and helps us to understand emerging problems before they become deeply entrenched. This year's report, adopted in July, assesses the follow-up to the recommendations addressed to member states, which we introduced into the cycle in 2022. These recommendations cover positive practices and reforms, which should be further pursued, as well as problems which need to be addressed. Overall, around 2/3 of the recommendations have already been followed up, fully or partially. The report fosters a true rule of law dialogue in the EU and is becoming a driver of positive reforms. This is, however, happening at various speeds and levels of completeness. And we also already have some serious rule of law situations in the EU which we need to redress. This is why, over time, we have developed at EU level a set of instruments to address problems. One such instrument is the general regime of conditionality, which aims at protecting the EU budget and the financial interests of the Union against breaches of the principles of the rule of law. This concerns those breaches that have a sufficiently direct link with the implementation of the Union budget. The Commission has been applying this budgetary conditionality regime since the start of 2021, and we remain fully committed to enforcing it. On the 15th of December 2022, based on the Commission's proposal, the Council adopted budgetary measures to protect the Union budget from breaches of the principles of the rule of law in Hungary under the conditionality regulation. The Council suspended 55% of the commitments under 3 operational programs in cohesion policy and also prohibited entering into any new legal commitments with public interest trusts or entities maintained by such trusts under any Union program. So the ball is in Hungary's court now to propose the needed remedial measures. Another instrument is the horizontal enabling condition on the effective application and implementation of the EU Charter of Fundamental Rights. This enabling condition is a prerequisite for the effective and efficient implementation of the shared management funds under cohesion policy. In concrete terms, all member states must put in place effective mechanisms that ensure that the implementation of the funding programs comply with the Charter. Importantly, the assessment in this context also covers whether the national procedures and mechanisms in place fulfill the requirements of effective judicial protection, including effective judicial review by independent courts. The non-fulfillment brings along consequences. The expenditure paid by national authorities in the course of the implementation of the programs may be included in payment applications, but the Commission will make no reimbursement until the situation concerning the fulfillment of the enabling condition changes. Moreover, the enabling condition needs to remain fulfilled throughout the whole programming period. Therefore, if at any point of time evidence shows that the enabling condition is no longer fulfilled, a reassessment will take place. The Commission also proposed to the Council to adopt Hungary's Recovery and Resilience Plan, which the Council did, equally at the end of last year. However, this endorsement includes the condition of a full and effective implementation of a number of so-called super milestones, including milestones on judicial independence. This means that no payment under the Recovery and Resilience Facility is possible until Hungary has implemented the milestones in question. Another way the Commission can respond when national law violates requirements of judicial independence is by initiating infringement proceedings. The Commission has done this in numerous instances, for example in the case of Poland, regarding the disciplinary regime of judges and other laws on the reform of the judiciary. I need to stress that all these are precise legal or budgetary processes, not political ones. All these instruments complement and strengthen each other. Some have seen the regulation on a general regime of conditionality as a magic wand that would cure all rule of law deficiencies and might thus feel disappointed of where we are so far with the use of this instrument. But there is no magic wand for the rule of law, because protecting the rule of law is never a one-off action. It is something which needs to be embedded in the basic pillars of democratic societies and defended every single day. It is not a task just for EU institutions, nor just for national authorities. It is something for each and every one of us, because rule of law, democracy and fundamental rights are the foundations of every European society. We need to act on all of them if we want to continue living in free societies. Next year, Europeans will vote in the elections to the European Parliament. Supporting high turnout, inclusive participation, easy and equal exercise of electoral rights, and resilient electoral processes are vital in our joint preparation for the upcoming European elections. And we have already been taking steps in this regard. The proposal on transparency and targeting of political ads will establish common high standard of transparency for political advertising services for all media forms and the strengthened protection of personal data. And it will enhance accountability and deter the misuse of advertising, including to disseminate disinformation and other interference. On the 23rd and 24th of October, the Commission will organize a high-level event on elections to foster exchanges of best practices that support turnout, empower inclusive citizen engagement, and other measures ensuring the resilience of the electoral systems and the fairness and transparency of elections across the whole Union. Disinformation is another challenge that we need to address, especially in the context of democratic processes like elections. When it comes to the role of online platforms in spreading disinformation, the Digital Services Act obliges online platforms to assess and mitigate risks related to civic discourse and election processes. Furthermore, under the Code of Practice on Disinformation, we will work with platforms to ensure that the commitments taken under the Code to limit the impact of disinformation linked to elections are put into action and monitored effectively and in a transparent way. And also the European Digital Media Observatory will play a key role in monitoring the EU information ecosystem ahead of the European elections, as well as in increasing citizens' resilience through targeted media literacy and fact-checking initiatives. These activities will build on the recently agreed toolbox to tackle foreign information manipulation and interference, which sets out the areas of situational awareness, resilience building, regulation and external action as key pillars of the work. The Commission's media initiatives are another important joint effort in supporting sustainable democracies. We are working now with the co-legislators to come to final agreements on EU rules to fight strategic lawsuits against public participation, the so-called SLAPs, and for a European Media Freedom Act to protect media freedom and pluralism. Because journalists and civil society more generally are key watchdogs for our democracies. They need to be independent and work in an enabling environment in order to keep us informed and to keep in check those in power. Dear participants, we cannot make concessions when it comes to protecting both the Union's financial interests and the founding values of the EU. We have a plethora of tools to address both issues. The key is choosing the right tool for the specific problems we need to solve and continuing to defend democracy, rule of law and fundamental rights at all levels with all our strengths. Thank you.